Well, hello, everybody, and welcome. Happy Thursday to you all. I am so happy to be here with you today. Lesli Bitel here, and I am joined by a very special guest today, Mr. Stephen Reich. We're really getting official, aren't we? Mr. Stephen Reich.
Yes.
And
Wow.
yeah, exactly. So I'm absolutely delighted to welcome Stephen to our show today, guys, because I really wanted to get more in depth on this particular topic. This is a really awesome topic. Many of you have had questions about this. So, what we're going to be talking about today is trademarking, right? So important. And specifically, how to pick a trademark that you can register and protect. And really key, and I know Stephen's going to go into much more detail around this, why you should do this before you launch your brand, ideally. Not to despair if you haven't
Right.
done this already, right? It's
Right.
not
Right.
like a fire drill. Um, but, I think what you're going to learn today is why it's important to do this sooner rather than later. Is that right, Stephen?
I could not have said it better myself. I think I'll just pack up shop and leave. You got it.
Great. I love it. All right. So guys, you're going to learn a lot, including what is a trademark, why you need one, what is registration, and do I need to do that? What if I'm already using a trademark but haven't registered? So lots of really critical information today. So with that being said, what I'd love to do, Stephen, is I'd love to learn a little bit more about you. This is actually the first time you and I have met.
Yeah.
So,
Yeah.
love if you wouldn't mind sharing just a little bit, maybe about your journey. How did you end
Sure.
up specializing? And I should say, Stephen is an attorney at law. Don't want to forget that.
Right.
So, how did you
Yeah.
end up specializing in this particular area of law?
Well, first of all, thank you so much for having me, and it's great meeting you. This is really exciting, and it's just fun to be on your platform. Um, how did I get into this area of law? Well, it's funny, like we were talking before, and I think a lot of folks out there, I had an interesting journey, and I have not just one career. I'm a lawyer, but I don't know if you and I talked about this, but I'm also an actor.
Oh,
So way back in the day, I was doing acting a lot, and I realized I wanted to also make a living. So I went to law school, and now I actually do both. But that's aside the point. The reason that's interesting is that the entertainment world got me into intellectual property, which is sort of what we're talking about today. And that can often be entertainment contracts, can be copyrights, but trademark goes hand in hand with that. So I think I was predisposed to that angle of the industry, and then I just kind of started to run with it.
great. So I
Yeah.
had no idea about the acting background.
Yeah, it's unique.
That's kind of cool. Yeah, and I can definitely see how that connection. So you decided to
Yeah.
go to law school so that you could kind of
Eat.
eat, right, pay the rent,
Yeah.
like pay the
Right.
bills, and
Yeah.
then you were able to merge these two passions. So that's
Yeah.
awesome. I love that.
That's great.
So all right, well let's jump right in then. And by the way, you are located where?
I'm in Boston,
Oh, you're
Boston,
in
Mass. I'm
Boston.
actually,
Okay.
currently I'm in New York, but yes, but I'm now currently living in Boston, Mass. Um,
Okay.
and I'm licensed to practice in Massachusetts and New York.
Okay. All right.
But the stuff we're talking about today is actually federal, so it doesn't necessarily matter
Okay.
where someone's located. Just to throw that out there.
Yep. All right. Yeah, that's important. All right.
Yeah.
All right. So let's jump in. Let's start by talking. Let's get some definitions, shall
Yeah.
we?
Yeah. Yeah.
So, what exactly is a trademark? And I'll preface this also by saying I think there's some confusion around trademark versus copyright.
Oh yeah.
Right? When she
Yeah.
said it. So can you
And
define that for us?
sure, and there's a good reason for that confusion. It's confusing, and the more I practice, the harder it gets. But very simply put, copyright is an original work of artwork, or authorship, as they call it. Usually books or songs or movies. Usually the artistic world, it can get businessy with business methods and code. But for the most part, you're in that world with copyright. Trademark is, very simply put, how you advertise what you're selling, whether it's a service, where we call it a service mark, or goods, where we call it a trademark. And what is it? It can be a symbol, a device, a logo, a short phrase. It can even be a sound, like Netflix's da-dum. It can even be, although I've never done one myself. It can even be a smell.
Okay, wow.
Some colognes I think go there, but for the most part, it's, mostly people use it in the realm of a name, or like a design that they call a logo. So it just, for easy vernacular, I use as an example Nike.
Mm-hmm.
Nike is the name that's trademarked. Then the swoosh is independently trademarked as their logo. And then Just Do It is independently trademarked as their slogan. So that's kind of a good basis. Apple, the same, the name, then the Macintosh with a little bite out of it. So those are trademarks, and they what they do is they tell the consumer, oh, okay, that product is made by Apple, and no shade to any PC owners out there, and I like Apple, so therefore I trust that brand and I will buy that computer. That's the idea.
It's really interesting that each of these segments are trademarked separately. I don't think I realized that.
Well, just because you brought it up, here's a really good point. Often people will come to me and I'll say, great, well, what do you want to trademark? And they'll say, I want to trademark my logo. I say, well, that's so exciting. And then I get it, and it's a name, a design, a logo, and it's like, okay, and not to get too technical, we call that a composite mark, but just simply because there's all these different elements into a mark. And, look, I think we're all in this space is somewhat of a creative space. And, we get very excited about our designs and the work that we put into the aesthetic of it, which we should. But trademark is very cut and dried. So when we do all that whole design, you can only use it like that from then on. So that would be as if Nike had the swoosh, the Just Do It, and Nike in some sort of picturesque design. And then they could only really get protection over that moving forward. That's why we like to separate them out, so you can spread out your soldiers. Yeah.
I see. Okay. I got it. Because otherwise you're kind of relegated to...
You're restricting yourself.
To using exactly how you see it.
There's, exactly is a strong term, but the core, you want to be as clean as possible with these things. That way that, you can stop someone. What if they just, well, we only took a part of your trademark, right? So you kind of want each one, if budget allows. Right,
because obviously it's
expensive.
It's going to ramp things up financially. Okay. So who needs one?
Yeah.
Can you help us figure that out? Because I think that is one of the biggest questions. I know that there's quite a bit of trepidation, maybe bordering upon fear in some cases, about putting our intellectual, our content out there, right? For fear that, it's going to get swiped. So,
I'm glad you phrased the question that way. Yeah. There's always, I deal with a lot of that in my industry, a lot of fear I think the first thing is, look, I don't want to speak too generally. We can't let fear stop us from progress, right? And yes, things get taken all the time. And we should take steps to protect it. But I don't want anyone to be analysis paralysis out here. I think with, who needs a trademark, right? I think if you're planning on or already selling a service or a good in a marketplace that you're not using your own name, it's a pretty big scope. You're trying to expand. Maybe you're interested in having investors look at you. I think it's valuable because, as we all know, we call it the goodwill of the brand. Leslie, I'm sure you're familiar with that term from your background. But for those of us who aren't, that simply just means there's more to the value to a company than just the bottom line profit and loss statement, right? It's literally goodwill. It's customers understanding that this product has done well for me over the lifetime, and I want to continue to have loyalty, and I refer and all that. So when you're protecting things like a trademark, you're really protecting the goodwill of your brand, and you're investing in it. And in the end, ironically, the trademark becomes more valuable than the brick and mortar. For example, Whole Foods, Amazon didn't buy Whole Foods for the groceries, right? They bought it because of the mega company it became with the name, with that name Cash. So it's just a long-winded way of me of saying, if you're a business that is looking to grow and you're using something that's, you're trying to source your goods or services in a way that, is not just your name, which even then you could think about trademarking. I think it's a very good investment.
Okay. So it sounds like it really adds significant value to your brand. It not only protects you, but it adds
independent value.
Independent value. That's a great way to put it. Okay.
Yeah.
So, can you help us with understanding? Let's talk a little bit more about when we should get this ball rolling, right?
Yeah.
And for what particular things in one's business, right?
Great questions. And we kind of talked about this backstage, I guess we could call it. Look, for me, if it's just off the cuff, the earlier the better. In terms of, well, we'll just start there. Yeah, I think the earlier the better because, and as I was telling you this before, there's sort of two sides to the trademark coin. One is what we call the offensive, which is I want to protect my mark. I want to keep others from using it. I don't want people stealing my stuff like we talked about before. And this is my brand, and I don't want counterfeiters or pirates or stuff like that. That's offensive use. Defensive use is before you get there, you got to find out if someone else already has the mark. And because if they do and you go out first, you are liable for what we call trademark infringement. And that unfortunately can be quite costly. Look, nobody wants a lawsuit. Nobody wants a letter in the mail from a lawyer. Even that's going to cost you money. So the game of trademark is to get ahead of it and pay, up. Look, it's one of those like pay you now or pay you later type of games, and later's a lot more. So earlier the better, but with the caveat that if you're more than a year out of launching, you can maybe wait a little bit. But I'd say, a year to 6 months, it's a good time and you're set on a name or a variety of names because the one you want may be taken. I think that's a good time. I think I love clients who come, look, I love all my clients, but I'm especially impressed by the clients who come to me who are saying, I think I have a name that I'd like to investigate if it's available because I'm planning to, launch my product in 6 months or my service in 6 months. I mean, that's where you want to be.
Right. Okay. So in terms of trademarking names.
Sure, we can start there. Yeah.
Would you say, okay, is it the name of the bit? I know you can do like the logo, all these different aspects. Would you do the name of the business or like the name of, let's say, a course, or maybe both? Maybe we're suggesting both, right?
I'll give you the legal answer, which is super frustrating. It depends.
Okay.
So one thing to not get confused about, which is, we all still trip up on it. The business name isn't always the brand name. So for instance, I'm trying to think of, I can't think of one off the top of my head, but let's say BizCorp, owns IBM. I mean, IBM obviously, but let's say that, they don't care about BizCorp. They don't care what's on the certificate with Delaware or they're New York where they filed their corporation. That's their corporate business name. That's the LLC or the Inc. that goes after it.
Yeah.
The brand would be IBM or Nike or Amazon, or, they don't have to be the same.
Okay.
Often they're not. So, no reason to feel restricted about, oh, well, I created a company and I called it this. I now need to trade. Is that what I have to trademark? You can trademark whatever you want as long as it fits in the parameters of the trademark office. So then that goes into a whole other topic of what name to pick if you're going to go on name angle. And that could be, I got a whole day for that, but I'm happy to get into it if you like. You point me in whatever direction. But that, I think that answers your question about the business. What do I trademark? Oh, and in terms of a course or the name or both, look, you're never going to be, as long as you use the mark as you've applied and gotten it registered, you can keep it forever theoretically, as long as you pay some maintenance fees and keep using it. But I wouldn't say to go out and trademark everything if you don't think you're going to use it all, because that's expensive, and then you're going to lose them. You'll lose them. It's a use it or lose it game. So let's say you got a brand and you're already in business, okay? And you're like, "Ooh, shoot, I need to make sure I'm not stepping on anybody's toes." So you'd search and clear the name you're already using. And if you had a course that you want to independently market, so it would be like, I keep going back to Nike. It's just the easiest one, but it's like Nike has the Air Force sneaker, right? So they probably have a trademark over the Air Force sneaker. But you know, in the beginning, I don't know if you need to trademark each course. You know, it's we don't need to spend a ton of dough. There's other things that can protect you in terms of, you know, pieces of your business, often through contract, of being ripped off. But you want to start with the thing that if you were like hanging a banner somewhere, or if you had a, you know, you're hanging a shingle, what would be on that shingle? That's what you want to start with.
Okay.
The other stuff you can investigate with your attorney on a case by case basis. Hey, you know, how aggressively am I going to market this outside of my already existing marketing? I think would be
okay. That makes sense.
The way to, yeah, I think like, you know, like Apple, like, you know, the iPod, right? I mean, that, you know, duh, like they definitely trademarked that, you know. But until you know, it's just very case by case. But we don't have to do that all at once.
Okay. So let's talk a little bit about registration then.
Yeah.
Is that different, or is it kind of under the same process?
So mostly what I've been talking about is registration.
Okay. Okay. So the registration
but there is a reason for confusion, because the United States is what we call a first to use country. Some countries are first to register. It's kind of like real estate or like title of a house or something, right? So in the United States, we value those who are, ironically, even though I gave this speech before, we value people that are using products and land, really, you know, but in this case, marks. So therefore, if you're someone who's never used a mark, but you want to, and you don't do a search, you just go and you file it. And then you get a cease and desist letter from someone saying, I've been using this mark for 10 years. And then you say, well, I registered it. If they've been using it, they have rights. They don't have as much rights had they registered it before, but they still have superior rights to you. So this is where it gets confusing, because it's like, well, what you told me? You just told me to go to register it, but now I could have not read. The benefits of registration is you get a lot of power in court if you have to sue.
Okay.
And you can get a lot more money back. We call them damages. You can get a lot more money damages if you have to sue. But on the flip side, if someone who doesn't have a registered mark but has a mark, we call a common law mark holder. They could gum up the works for you if you don't do that initial search to make sure they're not out there either. So registration is what I advise. Because it gives you the most power to protect your mark. If you don't register it, you're kind of at the whim of each state's rule, each state's laws, and you just don't have those powerful laws that the United States government gives a registered holder. It's a long-winded answer. I hope that helps. But, you know, it's so when I'm talking about mostly it's registration. Yeah.
Can you be using a trademark that's not registered?
Yeah, it's just not recommended.
Okay. All right.
So, yeah, look, I mean, chief justices have written novels on this stuff, right?
Yes.
But it's sort of, look, I mean, I guess an easy way to think about it is just driving without insurance.
Okay.
You can do it. You won't get arrested, but I hope you don't get a fender bender. Yeah.
Right.
Yeah. I think that's the easiest way to think about it.
Okay. So what about trademark infringement? Do you have any comments that you'd like to share on that topic?
Yes. God willing, this is the only way anyone ever has to talk about in the audience, because trademark infringement is basically what happens when you're using somebody else's mark or they're using yours without permission.
Yeah.
Okay. And that's where registration really comes into play, because if you have a registration that's proper, you did all the search and everything, and you're good to go, you can really knock that other fella or gal out of the picture. You can get what we call an injunction, which is a court order to stop. You can get your attorney fees back, assuming they have any money to pay them. You can get money damages. So it's very powerful. It's a very powerful weapon to have if you run into this issue. If you don't have any of that, which is kind of what I talked about before, you don't have as much recourse. But infringement is the big bad, hey, you're stepping on my toes in the same or very similar marketplace. So just one thing I want people to understand is like, hey, I want to trademark the name Squeegee, right? Or make it easier, Squibby. And I sell tires. But I saw that person who sells gum also has Squibby. And I would say, I'd look into the facts, but I would say, don't worry about it, because those are two separate classes of industry.
Right.
So there's I think the takeaway here in this like long legal treatise I've ended up giving is that it's all about, we don't want the consumer to, even though we're all the business owner here, so we don't want the consumer to be confused. So we think of it as when grandma goes to the grocery store and she's looking for her favorite brand Coca-Cola. And then she gets into the aisle and she sees Coca-Cola and Coca-Cola and Kula, and it all looks or like something totally different, but it's in the same packaging with the red and the cursive. She's confused. She's standing there. She says, what am I going to buy? And then for Coca-Cola's issue is, what if she buys Coca-Cola thinking it's Coca-Cola, takes a swig and it's disgusting, and she says, I'm never buying Coca-Cola again, and I'm telling all my friends never to buy Coca-Cola again, and there goes your goodwill hit. So it's all, at the end of the day, it all comes back to what we call consumer confusion, the likelihood of consumer confusion, and that's what we're always the touchstone. We just want to avoid that as much as possible.
Okay. All right. So can we try to boil this down into some action steps?
Beats me. I don't know, you tell me. I don't know. Yeah, we'll try.
What would you like, just for our audience who's listening, thinking, gosh, so what do I do first?
Quivering with fear now. Okay. So none of this is meant to be super scary stuff. I think it depends where you are in your business.
Okay.
Let's do the more common scenario where you're already cooking. You've been in practice for 3 years. You've got a name that people start to know you by. It's not necessarily your own name. It's a name you came up with. You're feeling really good. No one's come out of the woodwork saying, hey, that's mine.
Right.
I think the next step would be, in that scenario, assuming you want to take the step to protect your brand name, which I think is wise, you consult with an attorney who would conduct what we call a clearance search. And what that does is you scan the landscape. Usually attorneys use software to do that. It's a whole cottage industry to determine if there are other people or businesses that are using the same or similar mark as you, because it's all about similarity, right? So I think that's a really good step, because if you find out that there are a lot of folks out there, you're going to have to reevaluate. So I'll give a good example. This is kind of similar to this. I don't know, there's people from all over the states, but on the East Coast, there's a deli brand called Lenny's Delicatessen.
Okay.
And it has going to Lenny's. We're going to Lenny's. It's a huge chain in the East Coast. And then somebody in the southern, still on the East Coast, but in the southern states, had like a Lenny's, like a Leonard's deli sandwich shop or something. And they sued him. And Lenny's, which is a big bad company, had to change the name, and you saw them like taking down placards and stuff. So it can really dent your brand identity, and rebrand. As you all know, rebranding is expensive. Wow. So that's why I think being aware of the dangers is good. And then you can make a cost benefit analysis to whether to rebrand or to start over, all that stuff. If you haven't started yet, I think it's close to a no-brainer to consult with an attorney and do a clearance search. And see what's out there, with being open to a variety of names, because now you haven't wed yourself like the first example where you've already sunk all this money into advertising and labeling and packaging. You got to be open, and that's why I titled it "What's in a Name," because we get very, very wed to these and excited about a name we picked. But there's a lot of, not only may it already be taken, but the United States Patent and Trademark Office, USPTO for short, may say, you know what, that name, as cute as it is, it doesn't meet our standards of what is trademarkable. And there's a whole other, stuff we can talk about there. But what the trademark office does is they look in their own database and they say, well, somebody already has something too similar in a similar field, or this is too what we call descriptive of the goods, meaning like, I sell crunchy cupcakes. It's like, no, it's just a crunchy. You can't do that. It gives you too much. Right. Yeah. So you'd be surprised, but I get those a lot. But so you got a lot of hurdles that you got to navigate with it. I think with an attorney, because it's very difficult without having someone with a bit of a background in this, even though you can do it on your own, but it's as I think, as we can all tell from this, only half an hour, it's complicated stuff.
Yes.
Yeah. When you get to the granular level of it. And, you folks out there shouldn't have to be worrying about this. You should be worrying about serving your clients and your customers and building your business. And what we trademark attorneys are trying to do is help you with that. And then, we're kind of peering over the bow, making sure that iceberg isn't up on the horizon, so we can, steer clear of it. So I think it's never a bad idea to consult a trademark attorney, whether it's me or anyone in your area, to kind of guide you through this stuff. And then, you see if registration is right for you, and timing. Yeah.
So, if we've got folks in the audience who are interested in exploring this, how can they reach out to you?
Well, you tell me, should I put my email in the chat?
Yeah, actually,
I could do that.
Actually, it looks like we have some questions here too.
Oh my goodness.
Awesome. So let's see here. Oh, good. Yeah. Why don't you, I'll tell you what, you know what I can do? Why don't you tell me your email and I'll type it in and I will, I'll post it on the screen.
Okay. You want me to just read it to you?
Yeah.
All right. Stephen, Phen.
Okay.
J.
Okay.
REICH.
Okay.
@gmail.com.
Okay.
That's just a simple one.
Yeah. Stephen.
Yeah.
Okay. Hopefully I spelled that all correctly. I've been known to.
That looks perfect.
Yeah.
And that's my personal email, so we can,
Oh, thank you so much for that.
Yeah, no, you're welcome.
All right, guys. So this is great. So this is a wonderful option if anyone has questions or is interested in exploring. So, okay, so we do have some questions. Hey, Delia, how are you? So is the registration mark for a picture, i.e. a logo?
I think the question is, would a picture be a logo?
Right.
Hopefully that's the question, Delia.
I think it is. Delia, if we get that off, let us know.
We're going to talk about it. So, a picture. Yeah. Okay. A logo has a wide range of what it can be too. But you're not really going to trademark a photograph, right? It's going to be like something a designer makes, like a swoosh again, or like a leaf, or let's see, I got to pull it. This type of script of pull and spring, or sorry, that thing. Although the pull and string is a bad example, because ideally it would be something different than the name.
Right.
So let's think about, the M in McDonald's.
Sure.
Right. So it's something, a photograph is not in the trademark world. That would be a copy. That would be a copyright.
Right. Okay. Yeah. Because that's more like a creative thing, right?
Yeah, it's a good way to think about it, right? Yeah. That you want to protect the substance of the work, not what the work. And you wouldn't really have a photograph as a trademark of something. It's going to be some sort of design element, I think. I hope that answers that question.
Yeah. I think it does. Delia, let us know if we need to go into more detail. All right. She actually has another question. Does each state have a specific website link to go to check on the name?
Cross-check two sets. Well, the first one, I don't know about every state, but certainly most, if not all states, have a state mark registration department or list or whatever you want to call it. So in other words, you can get a state trademark. Problem is it only protects you in that state. So it's like, what do we, usually we end up doing that if we strike out on the federal register and we're in a big market, and we're like, well, maybe I can still just get it here.
Yeah.
And I can keep people in Georgia from using it, that type of stuff. But yeah, you can certainly go on state, I think you just Google like state, let's say like New Jersey trademarks or something, registration, you could probably find it. But it's not your best first step in terms of searching to see if it's clear or not. You can do those Google searches. You can check the USPTO website that has all of theirs. But again, I would recommend having an attorney do a proper clearance search, because you miss a lot.
Absolutely. And by the way, are you okay with time, Stephen?
Yeah. Oh yeah. Thank you. Yeah, I got a little wiggle room. Yeah.
All right. Just wanted to check.
Thanks.
Yeah. Let's see.
She loves Lenny's. Dealer loves Lenny's. Yes, I do too.
Yeah. All right.
She gets it.
Yeah. Let's see. Hey, Abby. Looks like if you retain the services. Yeah, absolutely. Yeah.
That's the idea. I will tell you, different attorneys have different styles, and some attorneys do what they call a knockout search.
Okay.
And that comes from patent law mostly, which is inventions. But the short of it is they'll say, hey, I'll just do a search of the federal database for what's been registered. Right.
Right.
Hey, no shade on that. To me, that's one eye blind though, because there's just because it's not been registered, like we said, doesn't mean it doesn't have potential problems for you.
So, hey Anna, good to see you.
Oh, here we go. But you do have another state or territory, so you need to check the dates. Right. So, deal's on fire. So that's why I think it's best to check federal, because it encompasses obviously all states. Yeah. If you go on state by state, you're gonna drive yourself crazy. But if you're here's the answer, right? Like, if you want to work nationwide, check the national database. If you want to work just in one state, which I don't know who in this industry, I don't know who's doing that, but then you can, I guess, just check your own. But even if it's just in your own, someone who's got a national mark
that's going to supersede.
Yeah.
Okay, got it.
Yeah.
Okay.
So I guess I'm kind of dumping on state trademarks, but
I think we need to look at
apply in Canada. Just to answer this, Angie, I'm not licensed in Canada, although it's a lovely country and I've been numerous times. But I can't practice law there. But I will tell you that the United States and several countries, obviously including Canada, acknowledge and recognize each other's intellectual property. So if you're doing business in Canada, you would have to get a mark in the States, but there's ways to do it. If you're living in the States, I would highly recommend getting a United States mark and then applying internationally, because wherever you first register is your anchor. And the US is a really good one because so many countries recognize it. But Canada's got its own system. I think it's very similar.
Okay, let's see. All right. So we talked about this a little bit. Can you answer that in a?
Yeah, sure. Difference between copyright and trademark. Just the strict definition is copyright is original works of authorship, like a photograph or a book or a script or a song. And trademark is basically a name a name, symbol, or logo, or something like that advertises your good or service. Okay. Some pictures, pictures are the realm of copyright.
What about a tag, like a tagline?
Trademark.
Trademark. Okay. That's what
Short phrases, for the most part, are not copyrightable.
Okay. That makes sense. Okay. Okay. All right. Thanks, guys, for the great questions. Appreciate that.
Yeah, put me to the test.
Work, right?
Man.
I love it.
Good thing I remember some at law school.
Oh gosh. Well, gosh, what a pleasure it's been, Stephen. Really appreciate your time
So
today.
fun.
Any parting words of wisdom before we wrap up?
Yeah, look, the earlier the better on this stuff. And consult with an attorney, even if it's just for a 15-minute consult or whatever, so that you don't unnecessarily spend money, but you don't but you do when it's, how do I say it? You don't unnecessarily spend money, but you spend wisely.
Yeah. All right. Speaking of money,
Oh yeah. How much? What's the price?
Like, yeah.
What's the price?
Can you like?
I will. I'll break it down. The federal government charges, I think at this point, $275 per application.
Mm-hmm.
Look, like anything, hidden fees come in here and there. And then attorneys each have their own rates. I'm not gonna, if anyone wants to talk pricing, we can talk offline. But I would say that generally you're looking, I don't want to throw shade on these, type of like legal, legal Zoom or stuff like that. But what you should know about those companies, they don't dispense legal advice. They basically just file for you. Now, I think, I don't know how they work. I think you can pay extra, but you're going to be looking at least $250 for the filing fee. And then for legal fees, it's going to go much higher, in the thousands, certainly, but nothing crazy. If you want to talk crazy pricing, you talk patent, which are inventions, and those are in the $9,000 to $25,000 zone. Okay. So we're below that. We're living below that, well below that.
Okay. Yeah, that gives us.
But it's an investment. It is definitely an investment. Yeah.
Right. Yeah, that makes a ton of sense. Okay, great question. Okay, guys, so you've got Stephen's personal email right here.
Boy.
That's
I'll rue that day. I'll regret that. What was I thinking?
Yeah, I know.
No, I'd be happy to hear from anyone.
Yeah, awesome. So this has been incredibly helpful. Really, really clarified so many of my own questions that I had, Stephen. So thank you. And I'm sure that those in our audience have a lot more clarity as well in terms of how to move forward and just how important this topic is, right? So
yeah,
not fear-mongering, but it does make sense to be assertive and proactive and and to take these steps, sooner rather than later, right? I think that's really the bottom line.
I think I agree, sooner rather than later. And I think if you're looking to scale in any way, you got to consider. I mean, I think it gets a little hard with this industry and with folks who run their own businesses because, we don't have the thought of like, I got to make an order for 600,000 sneakers in the next, we don't think of huge scale like that. We're person to person, we're service to service, but we still need protection for our brand if we're going to scale up.
Sure. Yeah, it becomes even more important. And everyone here knows we talk a lot about scaling, right?
We like scaling.
We like it. We like it a lot. And so guys, if you're not, if you don't have a plan to scale, then we need to talk for sure.
Then you got a plan to fail. That could be a trademark.
There's only one of you. There's only one of you. And at a certain point, you're going to run out of time. So, that scaling plan is going to be super important to move you forward. All right, guys. So thank you for joining me. I loved our conversation today, Stephen. I hope you have a great rest of your day. Enjoy New York City.
Thank you.
And safe travels to you. And thanks again. Bye, everybody.
Thank you.
Take care.
Bye-bye.